Good day, and welcome to today's UT School of Social Work webinar, Critical Elements for Victim Notification, Developing and Implementing Protocol and Practice. Our speakers today are Emily Burton-Blank, Holly Willock, and Caitlin Sully. Emily was the first justice advocate in the Houston Police Department's Adult Sex Crimes Unit. Developing the role as a liaison between investigators and victims, she provided emotional support necessary to balance the needs of adult victims of sexual assault with the demands required by the law enforcement investigative process to reach an appropriate judicial conclusion. Emily played a key role in the development and implementation of notification protocols for victims of sexual assault, as well as for the Sexual Assault Information Line. Currently, she works as a community-based advocate for a victim services nonprofit in Pittsburgh, Pennsylvania. Assigned to the Houston Police Department Child Sexual Abuse Unit since 2004, Senior Police Officer Holly Willock has conducted or assisted in over 500 investigations with hundreds of interviews with victims, witnesses, and suspects completed. She has been teaching at the HPD Academy since 2008, instructing cadets and officers regarding laws and issues surrounding the sexual abuse of children, and has conducted trainings with schools, hospital, and clinic programs, law enforcement agencies, and other institutions. She has been involved with the SAC project since 2011, assisting with data collection, victim notification protocols, and cold case investigations. And Caitlin Sully is a research project director at the School of Social Work's Institute on Domestic Violence and Sexual Assault. She currently oversees research initiatives focused on interpersonal violence, victim-centered practices, and the criminal justice system. I'm now going to turn our program over to Caitlin, and thank you for joining us today.
Thank you, Matt, for the introductions. I'd like to take a moment to share information on the Institute on Domestic Violence and Sexual Assault and our funder for this webinar series. Our mission at the Institute on Domestic Violence and Sexual Assault is to advance knowledge about interpersonal violence through research, education, and service in multidisciplinary strategic partnerships with researchers, educators, practitioners, policymakers, and other members of our community. IDVSA approaches this work from a multidisciplinary focus. The School of Social Work, School of Law, School of Nursing, and Bureau for Business Research are actively engaged in our mission. This project is supported by the Office on Violence Against Women at the U.S. Department of Justice, and the opinions, findings, conclusions, and recommendations expressed in this webinar are those of the authors and don't necessarily reflect the views of the Department of Justice, Office on Violence Against Women. At this time, I would like to extend a heartfelt thank you to Emily and Holly for presenting to us today and for their contributions to our field and to survivors. And particularly thank them for sharing their insight on developing and implementing victim notification practices and protocols. I turn it over to you, Emily and Holly.
Thank you, Matt, and thank you, Caitlin, for having us. My name is Emily Burton-Blank, and Holly and I are thrilled to be here today. Clearly, as you know from our bios that were just read, Holly and I were both part of the Houston team. So our direct knowledge absolutely stems from that project, and while we'll be mentioning some Houston-specific protocols, we really want to deliver today information about the process of developing notification protocols that are based in victim-centered and trauma-informed approaches and also are coming from multidisciplinary perspectives. So why even bother to develop protocols? We know it's important to have some standardization across protocols, really to ensure that victims are receiving information that they need and are also receiving the support that they need. So we need to establish kind of a baseline, but also to have the flexibility to address individual needs of victims. What we also know is that there are some key differences between cases that are current sex crimes cases versus cases being opened up due to new information years down the road. And one of the largest differences is the unexpected nature of notification. So in current cases, Victims are told after the initial report to expect a call from a detective, maybe a few days or a few weeks from the original report. And if they're not told to expect a call, then they're probably told to follow up themselves. In any case, there is an expectation of contact in the near future. On the other side, in these cold cases where new information is being found, that notification is completely unexpected. It comes out of the blue. Victims have described it to me as ripping off a Band-Aid of an old wound that maybe they didn't even realize was still there. And that is going to have impact of potentially re-traumatizing victims. In the victims I've worked with, I had multiple tell me about flashbacks coming back, nightmares, increased safety concerns, and other different signs and symptoms of trauma. So you definitely see that coming back very quickly in this notification. And then additionally, expectations of the case from the past might be upheld by information coming out about the case now. So a lot of times these victims are assuming that their cases will work to completion originally, and that would include full analysis of the sexual assault kit as well. So having information that there's new analysis or new results has the potential to be startling, has the potential to cause anger, disappointment, frustration, and confusion. And then additionally, this could result in mistrust or distrust of the criminal justice system as a whole. So originally, if they felt that the original officer didn't believe them, if they felt judged, if they didn't feel that the investigator was working hard on their case, then this belief may be upheld to learn that the kit wasn't even processed to begin with. So then we could be working with victims who are distrusting of the criminal justice system as a whole, and that new investigator or that new person doing the notification needs to be aware of these issues and really be intentional about building a strong rapport with the victims upon notification. So some of the key concepts and principles that need to underlie notification protocols are as follows. So the first two, victim-centered approach and trauma-informed approach, really they need to be some of the underlying features of the victim notification protocols. So I know these terms tend to be kind of jargony, and we all tend to throw them out there, but we really need to discuss what they look like, and we'll just touch it briefly. So when we're talking about a victim-centered approach, we really just mean that the victim is at the center of all decisions, including a victim's choice, their safety, and their well-being as a whole needs to be the focus of decisions being made. And then on the trauma-informed side, that it's similar in that the victim's emotional and physical safety needs to be attended to, and that we should be educating victims throughout the entire process, accurate expectations, they can know what to expect, but also that service providers or any folks who are coming in contact with victims through the response process, that they should be aware of the impact of sexual assault trauma on the health and well-being of a victim. So what this means is there's no cookie-cutter protocols. There's not just a checklist of what needs to happen or shouldn't happen in the notification process. What it means is that personnel doing this notification need to be flexible. Flexibility is going to be key because we need to address and be attentive to individual needs of survivors. And then the last two features, the victimization and procedural justice, these two concepts were spoken about thoroughly in the first webinar, and if you haven't listened to it already, I would encourage you to go back and listen to it. And if you have listened to it, probably doing it again because it's definitely rich with information. So I'll just touch these briefly since they've been discussed before. So the forms of victimization, we have primary, secondary, and tertiary. So primary is the actual victimization, so that would be the assault. Secondary is the victimization by the response system, so maybe that's at the hospital or the EMS or police officer, kind of anyone along the way of the response system. And then tertiary level or form of victimization, that's victimization by systemic issues. So in the system that the sexual assault kit was not originally tested would be a tertiary level of victimization. So what we know is we do not have the ability to impact the primary trauma, but we can impact the secondary trauma. So that what that really means is making sure the folks who are involved with engaging victims, doing the notification, whether that's an investigator, advocate, prosecutors down the road, whoever that is, they need to be trauma-informed. They need to understand the way trauma can impact victims and be respectful of the needs and reactions of victims. And then procedural justice. We really need to understand that theory and have it kind of be embedded in our notification in order to reduce secondary trauma and also just provide a better experience to victims. So the idea of procedural justice is that justice or success in this process is not only based or is not only achieved in conviction rates, but in satisfaction of victims, so that their experience throughout the process, so that could be in front of the judge, that can be with the prosecutor, that can be with the police officer, that can be the SANE nurse. So regardless of the outcome, their process has the potential to impact their sense of justice. So the way we can focus on procedural justice and the way we can, or the key concepts to kind of hone in on, are making sure that victims' voices are heard, that they're represented, that they're provided accurate information, and that they're treated with dignity and respect. And at this point, I will hand it over to Holly.
And when you're discussing victim notification protocols, one of the first things that needs to be identified is your multidisciplinary team. Many agencies have some form of this probably already in place, whether it's as a broad response to a sexual assault kit backlog or as part of just a sexual assault response team. There might be the basis, the foundation for this. But when discussing specifically developing the victim notification protocols, the multidisciplinary team is very key to making sure that we do and address the trauma-informed and the victim-centered approaches across the board, and we are making sure that in response to making sure that the victim's outcomes are positive, we're on the same team, we are all following the same guidelines. So when you are forming this multidisciplinary team, the first step is obviously identifying the key players. And when you do this, you want to make sure that you do have this representation of all disciplines across on the table and providing their input, because the victim is impacted throughout the process from various players. When you obviously have the patrol officer making the initial response, or maybe it is at the hospital with the SANE nurse. If there is a delay in reporting, it can be with the actual maybe investigative unit if they've gone to that station to make the report. So obviously law enforcement saying you do have the district attorney's office and your prosecutors that need to be involved, because each stage of the system does have, not everybody will be impacted by that process, but if it does get to that point, we want to make sure that things are addressed and the victim is very aware of how the process goes in that level. When you also have, when you're dealing with, especially with the sexual assault kit backlogs and testing, you also have to get your crime lab involved to make sure that all the players that are talking with the victims understand what is in this report, what are the results, are we communicating how testing is being done and the results of this testing properly. And by having the crime lab personnel on board, that level of communication can be identified and can be made sure that we are passing this along to the victim appropriately. So once you've identified your players, you want to also build the relationships up. And this also, by building a relationship, establishes the culture and make sure that you have buy-in commitment from everybody involved and everybody at this table. And part of doing this is making sure that you set up the logistics of how you're going to meet. Some people might want the entire multidisciplinary team involved in the victim notification protocols, or maybe it's such a large group that to specifically address it, you might want to form a subgroup and then report back to the larger group. In Houston, we had the larger everybody at the table, and then there was a subgroup of most disciplines involved that did the actual meeting, development the actual writing out of the protocols. And then it was sent out to everybody on the team for input and feedback. So as something as simple as making sure who is responsible for actually putting together the document that lists the protocols, who is responsible for distributing these protocols and making sure everybody has these. These are things that when you have the open communication, when you have your team built, that is something that naturally flows and is a part of it, but you want to make sure that the routes of communication, how it's going to be done. Is it weekly meetings with follow-up emails? Is it monthly meetings? Once those protocols are in place, then if there are changes to be made, if there are updates to be made, who is the go-to person to do that? And that's all as part of forming your multidisciplinary team and setting that up. So within the team, you set up either the specific people in charge of that. Once you do have your team in place, there are various concepts that need to be addressed within this. Obviously, strategic planning. What is the focus of your notification protocols? And while we all know that it's victim-centered and trauma-informed, a lot of this has to do with what are you looking at as your agency. And it's directly related to the next 4 listed under there. What type of support system do you have set up? Who are your partnerships with? What are your resources? And then how are you going to communicate this to your community that this is what you have in place? Houston is a very large, diverse city with lots of resources available, as well as many partnerships available within us. So the City of Houston, Houston Police Department, we had many outside advocacy organizations, many hospital organizations, one primary, obviously, prosecutorial office, but the City of Houston actually is in 2 other prosecutorial jurisdictions as well. So what does that look like? So there are different things, and if you're a smaller agency, what are the different aspects that you have to look at? If you're mid-sized, you might fall in between that, and it has its own strategic planning ideas that you have to address and deal with. On organizational support, it is not just the people that the multidisciplinary team that you have to address. Each team member is a representative of an agency. You do want to make sure that that agency also is in full support of any protocols you develop. So there's that communication. It has to go all the way up, but it also has to go all the way down. You do want to make sure that you have the people actually doing the notification, whether it be the investigator or detective assigned the case. Is it an investigator with the prosecution's office? Do you choose to use an outside advocate to initiate that process? However you choose to do so, but they need to make sure the person making the notification obviously needs to have the support of their bosses and their organization to be involved in that partnership and working together. And regarding the partnerships, they need to be active. They need to be ongoing. If there is a change, if somebody is out, there needs to be replacements identified so that everything runs smoothly. If there is an issue, good or bad, who do we contact to correct and or commend for that experience? And then these resources within the partnership, within the multidisciplinary team need to be identified, and as well as in the community. When you do have these notification protocols in place, how are you going to make sure the community is aware? How is the community going to know who to contact within your agency when dealing with whether it's the sexual assault kit backlog or a current case? How is that going to look like? If somebody contacts the advocacy agency, who do they need to tell them to get in contact with to make a report? Or if they go into the hospital. So all this is all related, and it needs to be, everything needs to be brought to that multidisciplinary team to go on to make sure that once you do have the notification protocols in place, you can then run with them and get it going in the system. Any updates, modifications need to be made, go from there. And so in regards to methods, understand that when, as Emily described, we are not talking about or providing a rigid cookie-cutter outline to be followed. every situation is unique. Houston is the 4th largest city in the nation. We have a very large agency here associated with it. We do have a lot, we are very blessed to have a lot of resources with us in the city. Not all agencies regarding in law enforcement, prosecution, advocacy, hospitals have the same resources. You do have to adapt to what's available to you. So in this sense, when we talk about how do we get into the methods of notification, this is the questions you need to address. Who is notified? On victims in a case, you're obviously going to attempt to reach that complainant and notify them about their case. But what are you going to base that on? At what point do you make that contact? Do you attempt the notification? Is it based on the end results of the SAC analysis testing? Is it only upon a CODIS hit? Is it upon any evidence that's CODIS eligible, meaning that a CODIS possible suspect profile has been loaded, but we have not received a match yet? Do you do it on cases in which there's no further testing to be done and the results were negative? There are some agencies out there that are going to do it based on whether or not the suspect can be located and or if there's going to be any additional charges filed on the case. These are all questions that you have to address. In regarding to this, the considerations you need to take place is remember the re-traumatization of the victim. What's going to be most helpful and provide that victim with a reason why you did recontact them. Houston's decision was we contacted all CODIS hits and let them know what the status of the case was, regardless of whether charges were going to be pursued or not, to let them know either the case was going to be ongoing. And then, even then, there was still possible investigation to be completed. For example, though, we did not, though, contact on any negative result testing because we had no new information to provide.
And then who conducts notification? Specifically, which disciplines will be involved directly or indirectly? So I'll speak to the indirectly first. What we mean by that and what some jurisdictions have done, or some communities who have dived into their untested kits, is at the multidisciplinary level, they have developed a group, either a subgroup or they're a whole team, to review cases prior to doing notification. Some have done that, some haven't. It's just an option to think about prior to notifying or doing any of the notification, and at the point of developing protocols. It's a good discussion to have. And then directly, who is actually making notification of the victim? Is it going to be law enforcement, prosecutor, or investigators based at the DA's office? Will advocates be involved, either systems or community-based advocates, or medical personnel? Who should and who seems to be the most likely or the most beneficial to do notification? Our recommendation is that whoever does notification, first and foremost, should be knowledgeable about the case. If we are risking the re-traumatization and notifying victims, we need to have someone who is aware of the case, has read through the entire case report in its entirety, maybe has an idea of what will proceed or what the options are for the victim to proceed or not to proceed. Without having someone who is knowledgeable, I would think the potential of re-traumatization would be a little bit higher. If we're notifying someone but then also not being able to provide any additional information, it doesn't seem really all that helpful in the moment. And then also, we would recommend that an advocate either accompanies the notification personnel or is a follow-up person. So in our case in Houston, we actually developed a CODIS squad. There was a CODIS squad on the adult sex crimes unit and a CODIS squad on the child sex crimes unit. And those investigators were only assigned these cases. And I, as the advocate, worked closely with both squads, with both teams. Sometimes I would go and do notification in person with each of the investigators. And sometimes I would do a follow-up phone call. And sometimes they would give the victim who was notified my number so they could call me. So it just kind of looked different, a little different for each victim, but every victim knew an advocate was available. That was the key. And we also provided information to our local rape crisis center because, of course, we know differences between systems and community-based advocates. A huge difference is the confidentiality. So we want to make sure to provide the confidential role, or confidential advocate should be available to the victim as well. So we absolutely provided information for contact as well. And then Detroit, they are a little bit different in the way they did notification. They actually had investigators based at the DA's office doing the primary contact, and oftentimes the original or the first contact was without the advocate, but an advocate was ready, kind of on call, if you will, if in that initial notification a victim wanted an advocate to be there, they could be there. And then how is notification taking place? So the options that seem to be the most common are going to be in-person, phone, or letter. And those alone can be kind of tricky to think about, and I think as you go through it with your team, discussing the pros and cons of each one is going to be important. So, you know, for example, for in-person contact, a pro is that you can confirm identity of the person. You can assess the traumatization in real life. But a con is potentially breaking confidentiality. Who knows who else is at their home with them, or if you're contacting them at work, they may not want coworkers to know that police are involved with them. It's also resource heavy to send either officers or investigators at the DA's office out and knock on doors. It's very resource heavy. Phone, a pro is that it's really not all that resource heavy, and you can make initial contact over the phone and then schedule another time to talk. A downfall is we all know people change phone numbers pretty frequently. And then lastly, I'd like to talk about a letter. So it's definitely resource light. You can have kind of like a standard form that you fill in based on the victim's specifics, if you will, and then you can send that out pretty easily. The con is that it's incredibly impersonal. When we first started talking about notification protocols in Houston, University of Texas was able to do some interviews with survivors of sexual assault who hadn't been contacted about their case. And so we said, if this was the example in your case, if you were about to be re-notified, what would you choose, or what would you like type of notification? And when they provided a letter, just kind of like a basic form letter, the reaction was really, really poor. I mean, they very much felt it was impersonal. There was concern about breaking confidentiality. What if someone else reads it? If it's too broad, then they may not know what it's about. But if it's too specific, again, you're risking traumatization when they're all alone, and you're also risking them not knowing what it's referring to. So that's just kind of some of the three things to look for. And then out-of-state notification. So how exactly is that going to work? Thinking through, are you able to work with local law enforcement in whatever jurisdiction they're currently in, or can you send your own investigators? And then what about local advocacy supports as well? What does that look like? Just really thinking through all of these kind of what-ifs for how to notify is going to be critical to begin with. So I'll tell you briefly in Houston, our decisions, the first point of contact would be from our CODIS squad investigator via phone, and basically they would introduce themselves as a detective from Houston Police Department and say there's new information on your case from 2008 or whatever the date was or the year was, and then that would kind of foster conversation from there. If a phone call was unable to be done, they would go in person to the house and try and meet with the person, and after that, if a contact still couldn't be made, they would send a letter requesting contact, also providing my name and number as an advocate, and then also providing the local rape crisis hotline as a different resource. And then out of state, we did work with local law enforcement. So an officer, our detective who was assigned the case, would attempt to reach out to the victim by phone and then set up a time for local law enforcement to meet with them when needed. And then I, as the advocate, would search for a local rape crisis center and then make sure the victim knew they could get in contact with them as well.
So once the victim is contact, or once the next thing to be done is when will the notification take place. Obviously, we addressed this a little bit when regarding who is notified, in the sense of that can be a determining factor. Obviously, we are going to notify the victim, the complainant. However, if there is any, when you reach trouble in trying to get a hold of them and you are reaching people that are claiming to be family members and or best friends or that kind of situation, you need to be prepared to what information is going to be released. Obviously, you protect the confidentiality at all costs. If you do need to make sure and stress that it's important, especially with family members, a lot of times if you will mention something generic like an incident that occurred in 2008, if it's a close family member or friend, they will know exactly what you're talking about, and a lot of times they will ask, is this in regards to the sexual assault? And you can choose at that point, based on it, to answer either neutrally or affirm. We found that a lot of times we proceeded with a follow-up question to maybe understand the relationship a little bit better before we answered affirmatively, but most of the time we did try to keep it neutral. However, everything is case dependent, and again, flexibility is the key. Knowing what to release might be dependent upon what the case circumstances are, maybe the age of the victim. If the victim was a minor at the time, maybe you discuss with the parent, but then those are other considerations to take. So when will you make the notification? Is it the testing? Is testing the determining factor? Is an assignment reopening the case? Not all cases that got reopened had necessarily a new suspect information, but there was further information that we felt we needed to reopen the case. So do you do it at that point? Is it after you know whether or not the prosecutor is going to continue the case, either with charges or if they've declined charges? So these are all questions that various people and that have asked and that we determined as part of your MDT onto whether at what point to address. When you do make that notification, obviously keeping in mind the secondary re-traumatization and making sure the advocate is available. Most of our cases here in Houston were done upon reopening. The investigator was tasked with making the contact with the victim, along with the advocate being available, and then was taken through the course of the investigation and then told at the conclusion of the investigation what that was. And related to the notification, what information is provided? This probably is one of the most that's case specific, and also it determines if you are able to get a complainant on the phone the first attempt and they are been waiting for the phone call and they want to talk to the investigator or whomever's making the notification about, then it's going to proceed just like a current case would. You're not going to see a lot of the hesitation due to the delay, that mistrust factor of not recontacting. So when you have that best case scenario, there's no difference in that cold case versus the current case. But a lot of this on what information is provided is very victim dependent. Keeping in mind that minimizing the re-traumatization is key at this point. So when you make that initial phone call or in person, or they have reached out based on that letter, you have to gauge what that victim's response is. Because if you have a very hesitant victim and you start bombarding them with information related to, let's say, a CODIS hit or case facts, and they are still trying to even process that law enforcement is contacting them, it might affect their ability on whether or not they want to stay engaged in the system. So the ability to adapt with each victim's response and understanding that response, that as I can speak to as investigators, we want to move on. We want to get to the next step and continue that case. But if it takes 4 phone calls or 6 months to get that victim comfortable enough to come give us a statement, then that is what needs to happen, because we want to make sure that we
the re-traumatization, again, is kept low. So the timing might be case dependent on the victim. The main thing with developing your protocols and having something in place that you follow, though, is consistency. What I'm doing here in my office is the same thing my coworker is doing in the other office, whether we're in the same building or we're in different buildings. So we want to make sure that I'm doing the same thing my coworker's doing, because that also ensures that the advocate involved knows what to expect as well. We want to make sure that we give them accurate information and keep them accurately informed. If the DA has already declined the case based on factors and we are calling them to give them that, we want to make sure and be upfront about that, about I'm calling you to notify you that the testing has been completed, this is what has gone with the case, and this is the result. Or maybe it's a matter of the suspect can't be located, or maybe you reopened a case that didn't have any additional testing, but there's other reasons the case is being opened. Make sure that the information relayed is accurate, and make sure that the next step relayed is accurate as well. And it goes into being honest about the case and knowing what's going to happen with their case, because each case is unique and case dependent. With regards to the resources available, you want to make sure that whether your victim is local or in out of state, they do have all the necessary contact information. If you are working with another agency and working with a detective from another agency, not only do they have your contact information, make sure they have their contact information. If you can, provide a phone and an email. In today's world, a lot of times people will put into words what they might not call you about. If you have an ability to text as well, obviously with younger victims, I've noticed that if they have that ability, they're more willing to outreach then, and you can explain. And when you do need a phone call, they understand you really do need to talk to them. In regards to Houston, what we did was we tried to speak with them directly first by phone, if not in person. But we made sure that if we showed up in person and they needed time, we provided them our information and we left. You have to keep that victim-centered approach in mind and be flexible to work with that victim on what their best practice is going to be as far as proceeding with the case.
So then as we're going through the protocols and still developing them, one of the key pieces of understanding is making sure that we're providing choice and control for victims in this process. That is key in reducing the impact of trauma and increasing the procedural justice, the things we've spoken about before. We do know also that being provided choices is empowering to an individual, especially when the system that they're involved in has really little to no control for the victim. So how do we do this? All right, so let's talk about the three kind of levels. There's three different places of choice or control to victims. So prior to notification, that's really hard. It's really difficult to provide choice to an individual that doesn't know they're going to be notified, but it's something that is requested time and time again. So how we chose to go about this is the first step was doing some community education. So that for us included media releases, newspapers, social media, local TV and radio stations, talking to the community and telling them honestly what's being done. How many kits do you have? What's your plan on testing them? What's your plan on investigating when they even get back to the city or when they are tested? For us, our goal is really to be honest and get that community engaged and get them knowledgeable about what's going on. And then also going one-on-one to local groups, so whether that's nonprofits, domestic violence, sexual assault agencies, agencies that focus on issues around housing instability or homelessness, different therapy agencies, churches, schools, really anyone who may come in contact with the survivor, just to let them know, again, you might be hearing from your clients or your church congregants or your students or whoever that they may be notified and this is what's going on, this is why, to kind of have buy-in from the community as well. But it shouldn't stop there. So another key point for providing that choice prior to notification is providing access for survivors to seek information from the notifying source on their own terms. So for us in Houston, we developed something called the Sexual Assault Information Line, and that was a phone line and an email address that was responded to by an advocate during working hours. So a lot of times that was myself. And so if someone called in or emailed in, I'd make sure to collect any information, any contact information for them, any information around their assault, what date it is, or if they know date or at least a year, location, and then what information are they looking for? Do they just want to know if their kit was tested? Do they want to know if it was ever presented to the DA? And people have really different questions, and it was really informative, I think, for us to know the questions that were being asked. So just providing that resource allowed for people to seek information out on their own accord. So then during notification, after initial notification, what that really means is affirming victims that they're being heard and that their perspective and their viewpoint and their decision matters. It is so important for victims to hear that from the professionals in the field, from the folks doing notification. It is incredibly empowering. And then also to meet the survivor on their terms. So after the initial, maybe the first point of contact was by phone, and then they're willing and wanting to meet in person with the officer to get a little bit more information, allowing them to choose where to meet. We've had folks say, can we meet at the Starbucks on this road, or can you come to my house, or can we go to the local DV agency because I already seek therapy there and that feels comfortable for me. That is really, really critical to allow them to make some choices in that and meet on neutral turf. And then also figure out a timing that works for them, accommodate for school, for work, for family. I know that leniency or that the flexibility can be a little difficult, but it is so critical for engagement and for them to feel respected and appreciated. And then, of course, allowing time for survivors to ask questions and allowing time to process. We're throwing out a lot of information at once when we do notification. Even if we go slowly and cautiously, it's a lot of heavy and emotional information. So allowing time to process. And for some people, that means talking to their therapist. Sometimes that means talking to their intimate partner or their best friend or their mom or a religious leader. And whatever that means for them, allowing that time to either process alone or with someone else is really, really important. So allowing for that. And then after notification. Choice after notification means allowing for the decision of the victim whether to engage with the criminal justice system, to decide I do not want to engage if they don't want to have any part of the case opening again, and also the freedom to change their mind. All of that is going to be really critical to allow them to know, again, their voice matters and their choice matters. And then finally, as we're thinking about all of these methods of notification, a few additional items that we want to talk about, and this is by no means an exhaustive list, but this hopefully will just kind of trigger in your mind other issues that may come up, other topics to think through for your notification protocols prior to doing notification. So one is confidentiality, and Holly's already mentioned some of this so far, but really being protective of the information you're providing, especially if it's to someone who is not the victim themselves. This is why it really is key to review the case in its entirety prior to notification. One thing we've really seen is you cannot assume that a victim's new intimate partner has any idea about the case. So even if they've been married for 10 years, if this assault happened 18 years ago, I would definitely urge caution not to necessarily bring it up even to a spouse or to a partner because they very likely, or they just may not know. So really being protective and keeping items and information confidential. Even if a family member is listed in the report, maybe if they brought the victim to the hospital or maybe they're listed as an outcry witness, that does not give full liberty to discuss the details of the case with them. so keeping that in mind. And then cases involving domestic violence. So maybe if the sexual assault occurred within the dynamic of a domestic violence relationship, items of consideration, just additional things to think about. Do the victim and the suspect share children? That could absolutely impact the victim's decision to move forward with the case or not to. Are there any additional criminal investigations, whether they're sexual assault or assault, between the partners in your system? And what you can't assume one way or the other is that the partners are separated or that they're together. So allowing kind of that space when that notification is being made, that they could be together, they could be separated, but don't assume either way is going to be pretty key.
And another issue is when the victim was a minor when it occurred. And some of them were still minors, obviously, when we recontacted them, so the parent-child relationship exists and discussing with the parent, but then you need to make sure and be aware, is the perpetrator, is the suspect about this case that you're recontacting on still within the family? So there might need to be some initial conversations with that parent to determine whether or not that offender still has access to that child. Obviously, if that child has since become an adult, their confidentiality is to them alone. So while as a parent, again, it still applies. Does this parent, were they protective in the beginning? Were they not? Is that the relationship that existed that you can release certain details? Because as parents, if they made the initial report, we're being protective, everything was fine, we assume that, and probably a rightful assumption, that they do want to know the outcome of the case. However, their child is now an adult, and that is their choice. It is up to them. So while you can stress that it's important that they contact us and stress what it's about, and the parent probably does know exactly why you're calling at that point, maybe to ease the parent's mind, you can also give them the advocate's information and they can explain some process and procedure without case specific. And then stress to them that once the child does recontact us, then we'd be happy to discuss with that victim, with that complainant's approval and agreement that we can bring that family member, that parent, back involved in the loop and keep them as informed, because maybe they still want that parent to be their personal advocate. And so sometimes allowing that parent, giving that parent the advocate's information to discuss just the process helped alleviate the fact that we're not discussing case-specific information to them. So just being aware of things like that and trying to get a hold of that when they were minors when the offense occurs. Just another point, special item that might need to be addressed.
Absolutely. And then we're going to wrap things up by just discussing some lessons learned. So at least from our point of view and lessons we've learned in Houston and what we think are important to consider during the protocol development process. So one of them is figuring out protocol efficacy. So determining as your MDT group, what defines success? How do you know if the protocol is working or not, and what your desired outcomes are? And I would encourage you to say not to limit yourself to thinking about success or desired outcome as numbers of arrests, numbers of convictions, but we really need to think about victim satisfaction. The overall justice a victim is receiving is really critical, but how do we measure that? That definitely comes up in saying, I mean, I cannot go on and on more without saying that how lucky we were to have two research institutions on the team with us in Houston. And if you're able to do that with a local college, university, community college, or someone who is in your community who has a research background, I would absolutely suggest reaching out to them. We had groups from University of Texas and Sam Houston State University, and specifically around research around victims being notified. We actually gave an opportunity for victims to reach out to be interviewed regarding their notification experience. So after we made initial contact, they were given just a little flyer to say, hey, you can call actually Caitlin, and Caitlin would do a brief phone survey, just kind of let them talk about their experience of notification, what they think could have been improved, and they knew that experience, although provided confidentially, was brought back to us so that we could improve our protocols, so we could get better in time. So again, I just would speak very highly of having a researcher on the team.
And one of the main things, once you've defined how you're going to determine success within your MDT, is you need to have that feedback loop. You have to have the communication open among all the partners. But it's not just the way the diagram is that you'll see on your screen. It's not just between the partners. Within each partner as well, you need to establish. So law enforcement needs to have a feedback loop within itself. Are we determining what is working and what is not working amongst us alone, and then also the advocates, what's working in outreach, what's working, because you have a comfort level when you start within yourself, what you're willing to say within your organization. Maybe you are having a communication issue with one of the other partners. Bring it up and within the group, and maybe it can be alleviated there because somebody knows a piece of information that somebody doesn't, or it can be addressed amongst the bigger partners and brought, but not just for bad, for good as well. When you have that experience that you were able to make contact with the advocate and they were able to diffuse a crisis after notification, and you got to see it happen in person. When that happens, you also want to give that feedback as well, because this is what I saw happen and this worked immensely. So it's both positive and negative, but that feedback has to occur. And it has formal and informal is best if you can. Like Emily said, the formal would be that research partnership, having that outside partner. And maybe it's not the research partner. Maybe you partner with your local advocacy group and say, hey, can you do a can you do an assessment on how we're doing with us? And you get it. If it's, if they want to be notified or corrected regarding case specific, then great. But if not, if they just want to tell you good and bad experience, but you come back and bring it back to us so we can assess and evaluate and adjust, then that's another way formal feedback can be gotten. And then informal, obviously, those emails that, hey, I had this, I spoke with the same today, and this happened. Those informal phone communications, emails, that kind of thing also needs to be established so that if something does come up, it can be addressed immediately as well. And also within that, you have your partners definitively identified. You have these feedback loops, formal, maybe you have the formal identified, but bringing that face to that name, who to contact informally. So all your partners can make sure that, again, we're keeping that victim-centered approach in mind to get to the desired outcome. So when we talk about the biggest lessons, what we found is knowing who to contact within our partners provided immediate feedback, and it also allowed us to make necessary adjustments almost immediately when necessary. When we were brought to the attention that, hey, when you do make in-person notifications, make sure and give them time to process and maybe tell them, hey, contact me back. Because we were wanting as investigators to go immediately into what needed to happen next and maybe get the statement and go from there. And what we were hearing from our research partners and from the advocates was like, hey, if you do go in person, you need to make sure and maybe just say, hey, this is who I am, this is why I'm here. When you're comfortable, please contact me so we can discuss further, and then leave. Because again, you're giving them the choice, because a lot of victims said that they felt like they had no choice because we were there, we took the time to go out there, so we'll just go ahead and talk to you, but I really didn't want to do it. You give them the choice, and that was a very distinct lesson learned. And one of the biggest lessons learned in Houston is how important that advocacy role was throughout the process. If there's one thing that the unifying theme throughout is having an advocate at the hospital, having an advocate during the investigation, having the advocate during the prosecutorial aspect of it, and it's not necessarily the same advocate, having that outside advocacy agency available. When we had that advocate throughout the process, it made across it, I'm pretty comfortable speaking for the prosecution side and the SANE side, it made everybody's job easier, and I do believe it made the victim's process a lot easier in the sense of she had a better understanding of the entire process and had her questions addressed.
And then finally, this is our last piece, is that notification is ongoing. It doesn't just stop at the initial notification or the second meeting. It has to continue. So it goes on with feedback from survivors, with follow-up information if there's any new information or any updated information. But it doesn't even stop there, because this also includes a survivor if they decide to disengage from the system, but maybe a survivor who then decides to re-engage with the system. So again, we're talking about the flexibility, the customizability, and it absolutely includes survivor making contact, maybe requesting an update, just seeing what's going on. And this includes information from the investigator, or reach out from the investigator, reach out from the advocate, and then, of course, reach in from the survivor. So this continual communication is really key, and it will help, again, reduce trauma amongst the survivors and also increase their procedural justice. So with that, thank you very much. Holly and I are very happy to be asked to be here and speak with everyone. You can contact us very easily via email, and then I will hand it off to Caitlin.
Thank you, Emily and Holly. I do want to mention that if you have any questions following the webinar, anyone can contact me. On the slide here is my email address and my phone number. We will also be archiving this webinar within the next 24 hours. If you have folks in your office who aren't able to attend and you'd like to share this information with them. And we'll also be presenting at National Sexual Assault Conference in the end of August, beginning of September, if any folks are going to be there and you want to come say hi. And lastly, we've been gathering all of the technical assistance requests and writing a victim notification guide that will be available to everyone in the fall. And I received a few questions throughout the webinar, and although we're out of time, I will be responding to these questions, and we'll send those responses out to all of the attendees. And I also wanted to mention that we heard from one of our attendees that from Memphis that they have a weekly meeting with their DA's office where they're able to staff these cases together and determine the notification efforts with those survivors and specifically tailor them to that person's needs. So I wanted to mention that practice, and it's a really promising one. So thank you for sharing that from Memphis. Just like to thank Emily and Holly again for their insight and sharing their experience with launching the CODA Squad unit and the justice advocacy around untested sexual assault kits in the city of Houston. And thank you to all of our attendees for your work and contributions to survivors every day. Thank you.
That concludes our session today. I would like to thank our speakers for their participation and all of our registrants for attending today's program. You can register for on-demand recordings of past webinars and upcoming live programs at UTAustinSocialWorkCEU.org. Thanks again, and have a wonderful day.